Welcome to BattleTested with Tanya Acker. This is an episode dedicated to all my friends out there who are now or who may be being battle-tested in court, because court is really a proving ground like no other. It's not enough to just show up and be right. You have to find a way to lead the judge or the jury to the decision that you want them to reach, and you have to do it within the confines of very specific rules. And those rules cost real people a lot of money. And frankly, the best way that I feel like I can demonstrate that to you right now is by talking about a dispute that involves some of the richest and most powerful people in the world. And of course, you know I'm talking about the president's lawsuit against Dow Jones and the Wall Street Journal and Rupert Murdoch that was dismissed this week. So just to recap, the Wall Street Journal reported that a letter bearing Trump's name was included in a birthday album for the dead and disgraced Jeffrey Epstein. President Trump said, "That is not me. It is a lie. And if you print that, I will sue you." So they printed that and he sued them. And the president brought his lawsuit in July of 2025. So that was 9 months ago. So I want you just to remember that this is a fight that's now being staged between the most powerful man in the world, certainly one of them, and a very, very wealthy man, wealthy before he came to office, wealthier even now, and one of the most powerful media organizations in the world. There's this phrase. It says you don't pick a fight with somebody who buys ink by the barrel, because if you're fighting with a news organization, they can write about the fight and then it gives rise to all kinds of stuff. You're fighting somebody who won't stop talking. So you've got somebody who cannot stop paying with somebody who won't stop talking. Okay. These are the warriors in this fight. So the president sues the Wall Street Journal, files his complaint in July. Now, the position of the Wall Street Journal is it doesn't matter if none of this is true. We still win, and I'll explain that in a minute. But before we get to their motion to dismiss, which is what that is, the president wants to depose Rupert Murdoch. And he said, I have to do it on an expedited basis because he's 94 years old and he might be too sick or he might be dead by the time we get to discovery. But then the parties agree that, you know what, we're going to hold off on his deposition. But that was not without strings, because the Murdoch team had to give regular reports to the president's team about his condition. And if they didn't comply, then President Trump could have required a deposition on really, really short notice. So they say, for now, we're going to just put this off. Now, I want you to pretend like that this is you. And instead of it being a fight between the president of the United States and one of the largest media conglomerates in the world, let's say it's somebody trying to depose your grandmother. And let's say you say, look, my grandmother's sick. Can we just put this off until we resolve whether or not there's even a case here? And they might say, I don't know, maybe, maybe not. So maybe instead of that stipulation, you are actually paying a lawyer money to go to court and say, hey, let's not depose my grandmother right now because we may not even get to discovery. We may not even have a case. Okay, but in this case, they didn't get there. They agree, we're not going to depose Rupert Murdoch until we decide whether or not there's a lawsuit here. So after the president files his complaint, the Wall Street Journal files what's known as a motion to dismiss. And what that means is, I don't care if I did everything that you say I did. You got nothing. You have no case. Go away. Bye-bye. And the reason why the Wall Street Journal said there's no case here is because, one, they say it's true. But remember, that's a factual thing. And so that's harder. President says it's not true. They say it's true. That's going to require discovery and probably a lot more additional information. But in any event, they say this is true. That's their first response. The second response is it's not defamatory. And I suppose the thinking there is that all we said was that there was a birthday card with certainly a suggestive drawing of a woman sent to a sex offender. And we didn't say you were a sex offender. We just said that you sent a sex offender a birthday card. I suppose that would be the argument as to why it's not defamatory. Now, if I'm on the president's team, there are two types of defamation. There's defamation per se, like, for instance, if you accuse somebody of committing a crime. And there's another type of defamation per quad, which means, like, if you put everything in context, you're suggesting I did something shady. So the argument that it's not defamation, we'll just put that aside, because the judge, when he dismissed the president's lawsuit, went with option number 3, which was, even if everything is false, even if they totally made it up, they did not do so with actual malice. And so this was the third argument that the defendants made in this case. Even if it's not true, even if it's not really you, it's not defamation because you're a public figure. And if you want to sue a public figure for defamation, you have to show actual malice, which means that you have to have published these facts with reckless disregard for whether or not they were true. You can't just say, you knew it wasn't true. You have to plead facts that show that the person who said these things knew that they weren't true, okay? They file a motion to dismiss. They also file what's known as a request for judicial notice, another pleading. And a request for judicial notice is when you want the court to put something into the record which has already really been verified. So it might be like a newspaper article or some public document, something whose legitimacy is not in question. The president's team files an opposition to the request for judicial notice. They file an opposition to the motion to dismiss. The defendants file a reply to those papers. And the reason I'm pointing this out is because I want to tell you right now, that's 6 pleadings filed in about 9 months. I don't know how much those pleadings cost. I don't know what the president spent on this case. I don't know what the Dow Jones lawyer spent on this case. I do know that each of those motions, each of those documents, each of those pleadings in high-end contested cases can cost you tens of thousands of dollars. I am not exaggerating. Been there, done that, seen it. And it's not because lawyers are all shady and just making stuff up. I'm not saying that nobody is, but that's not why litigation is always so expensive. It costs a lot of time. It takes a lot of time and it costs a lot of money to try to prove things in the way that you have to prove them in court. If you look at my book, Make Your Case, Finding Your Win in Civil Court, I will explain to you all of the reasons why. So I don't know what they spent, but I do know that we've got 6 pleadings and you can easily spend well over $100,000 on those 6 pleadings. So let's go back to what the judge did this week. What the judge said is, I am dismissing this case. I'm dismissing your lawsuit, President Trump, because you have not pled facts that are sufficient to show actual malice. Because they didn't act in reckless disregard. The journalists asked the president's team for comment before they reported, and they'd also reported on their own investigative efforts to try to figure out whether or not this was true. And Mr. President, I'm going to give you until April 27th to refile your complaint where you can plead facts that might be sufficient to show that there was some actual malice. But right now, all you've done is plead conclusions. And that's nothing. That's like saying they recklessly disregarded the truth because I said they were lying. And that doesn't fly. It's not like you can't say you're wrong because I say so in court. You need more. So the president has until April 27th to refile the complaint. And again, what have we not learned? We do not have a ruling on whether or not that's actually the president's signature. We do not have a ruling on whether or not the facts that were in that Wall Street Journal report were true or not. We just have, after 9 months, a ruling that says, go back to the drawing board and try again. You can leave a note in the comments about whether or not you think the president is going to refile. They've said they'll refile. I think he'll refile. But put that aside. It's 9 months. We don't have an answer. What does this mean? This means that when very, very rich people go to court and spend hundreds of thousands of dollars, I don't know what they spent, but I'm guessing, on pleadings, they may have a stomach for it. The president of the United States and one of the largest media conglomerates in the world probably have a big stomach for litigation. Surprise, surprise. Who probably doesn't have a big stomach for litigation is you. I'm guessing you don't have President Trump's money. I'm guessing you don't have the resources of the Wall Street Journal and the media conglomerate that stands behind it. I'm guessing you don't have the resources of Rupert Murdoch. And I'm guessing that when you go into a situation like this, because you don't have to be rich and famous for people to try to make things up about you, and the pleading standard's a little different. You don't have to show actual malice if you're not a public figure, but let's just put that aside. Litigation is expensive. So my note to those of you who are in battle right now in court, and you may not know where I'm going. It's going to sound so basic, but trust me, you will be glad for this. My note is get a budget. When you have a lawyer and he says, I'm going to go, or she says, or they say, I'm going to go to court. I am going to fight the fight. We're going to prove this wrong. You don't just be happy, because you will be happy because it's hard to find a lawyer. You'll be so happy somebody took your case, especially if you don't have boatloads of cash and you found somebody who's willing to take the case, but they may still be charging you hourly because it's hard to find a lawyer, by the way, who wants to take a case on contingency because they're really taking a gamble on you. Ask for a budget. And don't just say, how much is this going to cost? Say, what are the steps? This is you now. This is you talking. My ex-boyfriend put up these ridiculous photos of me. They are AI altered. I want to sue him. I'm going to get him to take them down. I want to make him personally liable. I'm going to do all of these things. You get a lawyer who says, yes, we're going to do that. We're going to go after this dog. We got him. Don't get too happy yet. Ask how much it's going to cost. Ask how many pleadings will be filed. Ask what pleadings. Ask for a rough estimate of how long it's going to take. If they don't know, ask them what they need from you to help them know. Because litigation is a battle. Court is a battle. It's a battle even in the best of circumstances. It's a battle even if you got the time and the money. And I promise you, your time and money can always be spent doing something better. So if you're going to be in that battle, be ready. Don't get bankrupted. This is battle tested. You are, and I want you to do your battle as best you can, especially if you're in court. I am Tanya Acker. This is Battle Tested. Thank you for joining me. And we have a lot of great episodes coming up this season. So I hope you will follow and subscribe. By the way, do you think the president's going to refile on April 27th? I wish there was a way to make some sort of wager on it, but I'm not gambling on that. I'll see you next time.